My name is Trevor Lecca. I'm Dubsato's Customer Education Specialist, and today's webinar is called Seal the Deal. We're going to be talking about legally binding contracts, agreements, and email consent. I'm really excited for this webinar because we get a lot of questions about what should be on my contract, right? If you're a Dubsato user. And it's a difficult question to answer because it's going to vary so much by industry. But of course, there are some things that you definitely should have in your contract, bar nothing else. And today's guest speaker, Jaime Bell, is going to be a really good person to ask some of your burning contracts questions to. Jaime is a business lawyer and the founder of the Contracts Market, which provides done-for-you legal contract templates for US and Canadian service providers, coaches, and e-commerce businesses. And I'm really excited to have her on today to answer some of those questions. So without further ado, let's go ahead and bring on Jaime Bell.
Hi, thanks for having me.
Thank you so much for being here, Jaime. We really appreciate it. Really do appreciate it. Let's go ahead and jump into it. Why not?
Great. I'll share my screen.
Sweet.
Great. Can you see everything now? Put it into...
All good on my end, Jaime.
Okay, great. Let's get started. So thank you for the warm introduction. Like Trevor said, my name is Jaime Bell. I'm a business lawyer and also an entrepreneur. So I think there's a lot of you in the room who have your own businesses. So I understand feeling sometimes like you need to wear all the hats. My job is to make lawyer not one of them. So we're going to dive in today and just get right into what you should be having in your client service agreement specifically, and then really dive into email marketing and how your marketing needs to be compliant with certain laws, and specifically email consent. When we were talking about what kind of topic would be top of mind right now, I think with Black Friday coming up, we're thinking about how can we launch offers, get the most from the season, and email marketing is a really important tool in the toolbox for having a great Black Friday sale. So I think it's a great topic to dive into in the season. Now, before I get too far along the beaten path, I just need to give you my disclaimer. So I am a lawyer, but I'm not your lawyer. So everything we're talking about today is just for information and educational purposes only. If there's something here that raises a flag for you and you need specific legal advice, I definitely recommend you seek out a great lawyer that actually understands online business or small business and email marketing local to you. There is often not a replacement for your own lawyer. So just keep that in mind as we go along. But if you do have general questions, please pop them in the chat and I'll be happy to answer them at the end. So just before we get started, I always like to take like a deep breath because legal and understanding this side of your business is not sexy, but it's definitely necessary. Usually when we're either starting our business or thinking about a new launch or an offer or promotion, we get really caught up in the logos and the branding and all those important aspects of business. But I don't have to convince you likely because you're on the Dubsato webinar that systems are really important in your business. And they're really important to have a foundation to protect your client relationships, to collect your hard work that you've spent so much time building in your business, and not leave yourself open to expensive legal risks. So the fact that you're here is great. And I want you to also give just as much attention to how you are going to protect your business and ensure smooth working relationships as all the other aspects of your business. But the good news is once you start understanding it, you become a little bit more confident in it and it becomes easy to issue spot when you need to either make changes or hire a lawyer to help you, or just navigate certain situations as they come up in your business. So good job, all of you, for being here on a legal workshop. So let's dive into contracts and the importance of them in your business. Specifically today, we're going to be talking about client service agreements, but there are various contracts that you will come across in your business, which we'll get to just a little bit. But essentially, most contracts have the job of first getting everyone on the same page from the start. Often we are coming into a relationship with our own stories about the obligations and what's going to happen as a result of the relationship. So a contract is making sure we all understand where we're starting from first. It also helps solidify an actual relationship, and especially from a client perspective, know that you've been hired. You would not be surprised, or you might be actually surprised to learn how many inquiries I get through my law firm that are like, hey, I thought I was hiring someone for this job, but it wasn't that job at all, and I'm disappointed. So it just solidifies the relationship and makes sure everyone understands what the obligations are of the relationship from the beginning. A great client service agreement also helps set and manage expectations, and we'll get into that in a little bit. It definitely acts as a reference point for when things don't go according to plan in the future. And the longer you're in business, the more you'll understand how often that this happens. And especially for your client service agreements, it shows professionalism and thoroughness, and that you're considering what everybody needs to know before you jump into a relationship together. If you have a contract as part of your client onboarding system, it's often the first point of real written content that your client sees and is going to set the stage for what they can expect from working with you. So, just a few things that your contract should be versus shouldn't be. It definitely should be a reflection of the relationship between the parties and setting out expectations. It definitely should be an extension of your brand, and that means that you can customize it so that it reflects your, unique um, brand voice, the actual language that you use with your clients. We are getting away from all this like old English language and legalese that everybody hates and nobody understands. So your contract, your client shouldn't have a degree in Shakespearean studies to be able to understand it. It should be really straightforward. Everyone should understand it, and not be complicated and complex. It should be fair while protecting your business. And I feel like this is something actually people who draft their own contracts get wrong, is that usually it's so in favor of the client that it's not worth the paper that it's written on to protect their actual business. They're so worried about clients not signing their contracts that they kind of throw the baby out with the bathwater. So it should be fair while also keeping some protections for your business. And then the last thing that I think people often miss the mark with is like, just make it easy to sign. I use Dipsato in my law firm, and that's how I have all my clients sign my retainers. But just making sure that however you're getting contract signed, we do not need to print these things out anymore. Electronic signing is as legal, or if not better, than wet ink signatures. So just make sure that your contracts are integrated into your system and easy to get signed, so that you're not starting work without having a signed contract in place. Just really quickly, your contract shouldn't be an afterthought. It shouldn't be something that you've started work, something happens and you're like, I didn't get the contract signed, or hey, I have this client who's ready to sign, so I'm just going to smash and like cut and paste something and get it together. You should have this thoughtfully ready as part of your onboarding system before any work starts. It shouldn't be something you're embarrassed to have. I often get people send it to like, oh, I know this is a terrible contract, but just sign it anyway. No, you should be proud of it. It's an extension of your brand and your professionalism. So make sure that you're proud to send it. A client service agreement or any kind of contract that you're entering into with anybody should not have clauses you don't feel comfortable enforcing. This happens with cancellation clauses, or what happens to retainers, which we'll talk about in a little bit more detail. So if you have a clause in your contract and you don't enforce it, and the contract said you would, an example of this would be you stop work if a client misses payment. You might actually be found to be in breach of your own contract if you don't enforce that clause. And I actually just had a client have this happen to them. So make sure that your contracts only have clauses that you're comfortable enforcing, and also that you're familiar with the clauses that you have in there so you can enforce them when it arises. And while verbal contracts and emails and texts and DMs have a chance of being enforceable, a great contract should be more official than that. It should be something that everyone's intentionally signed, and it should be all the things that we're about to talk about. So even though we're going to be focusing on client service agreements today, that's just one of the types of contracts you might encounter in your business. Another one are independent contractor agreements. So if you are hiring somebody as a contractor in your business versus an employee, that would be an employment agreement. Probably a lot of you are familiar with employment agreements, having been previously employed or currently employed right now. One we're going to dive into today is website terms of use and privacy policies. Again, not sexy, but it is actually a contract that you are signing with everybody who visits your website, and having people agree to the house rules of your website, and vice versa when you visit other people's, and check the box that says I agree to these terms. So let's dive in to client service agreements. Now, this is going to be either a refresher for some or totally new for others, but you can use this the presentation in a variety of ways. If you don't have a current client service agreement, you can use this as a checklist, things that should be included in one if you are drafting one yourself, or if you're hiring a lawyer to do it, or using some kind of template. Use this as a checklist. If you currently have a client service agreement in your business, this is a great, like, go go grab the precedent that you're using and just use this as a checklist, or you can use these slides later to just make sure that your current contract that you have covered these important points. Now, this isn't everything, but it's definitely going to give you a good starting point. So let's dive in. So, first things first, what are you providing and what are you being hired for in exchange for the fee that you're charging? So, yes, we have to be telling them what we're doing, but I also think it's really important to tell people what you are not providing, and get really specific about this. I think this is often where contracts are not specific enough in terms of the actual deliverables. And that's where scope creep happens, and people start feeling resentment towards their clients because they feel they're giving more than what they're being paid for. So be really specific. So if you're a social media manager, for instance, that means how many check-in points does your client get every month? How many posts per platform? What does a post mean? Does it mean stories? Does it mean reels? Like, what does that look like? What about captions, hashtags? Get really specific. You have to remember that you are the expert in the service that you're providing. And if I'm hiring a social media manager, I don't really know what your real job is. I just know what I want to get done. So I want to see that list. And your deliverables should often be specific enough to act as a checklist. Like, hey, yes, I've done this, this, and this, which is what I agreed to for my fee. And I'm not doing certain things. Using that example as a social media manager, that might mean, hey, as a social media manager, you're not paying me to do your Pinterest. So make sure that that's in there. And then this goes really hand in hand with one of my favorite clauses, which is your additional services clause. So this sets out what you could provide if your client wanted to pay you more. So this helps you really rein in the scope creep by saying, for my hourly fee or for another fee, which we can decide on, I can do all these things, but it's not actually what I'm being hired for under this contract. But we can always amend it to include those. Cancellation and rescheduling fees, these, think about them from both perspectives. You might not ever think you have to cancel a contract or reschedule, but life happens and you want to make sure that you have an option, and so does your client. And then what is the fallout from having to rely on a cancellation or rescheduling clause? What happens to a retainer if you've collected it? This is the same as a deposit, but we're really moving away from the deposit language and using retainer instead. So what happens to that money? Is it applied to the final invoice? If your client cancels, is it forfeited? What happens? Is there a notice period? Do you need 30 days if you're on a monthly retainer? What does that look like? Keeping in mind that if someone has to cancel a contract, it's pretty unlikely you want to keep a relationship going too long when someone doesn't want to work with the other. So just making sure that those are reasonable. Now, timelines and communication really flow and are connected with deliverables and additional services and all the things. When exactly are you expected to provide the deliverables? And if your work is dependent on your client providing you something, what is the deadline for your client? Going back to I don't know why I'm picking on social media managers today, but if you're a social media manager and you need some B-roll and you have a set deadline to get 5 reels uploaded into their portal by Friday, you want to make sure that your client has a deadline that is not Thursday night, because you need time to produce good work. So making sure that these things all are lined up so that there's clarity for everybody and you're not setting yourself up for failure. Fees, usually people get this pretty right. So making sure that you are setting out the fee, How are you accepting payment? I know for a long time in my law firm, I didn't actually accept credit cards, and this became a big sticky point for a lot of people. So letting people know how you can accept payment. And if you're working with international clients, this is really important that you understand what you can accept and how. When our fees due, and if you charge late fees. So if you send an invoice to somebody and they don't pay it, is there interest on that? Is there a charge? You cannot retroactively charge somebody a late fee if it's not in your contract. So this becomes really important if you ever have to start a lawsuit or get a collections agency involved. You want to make sure that if you wanted to charge interest up to the point when you actually get the money, which could be months or years down the road, depending on how much you're owed, that there's been an interest or a late fee charged. Other essential terms for your client services agreement include, again, disclaimers that are very specific to your expertise and service. If you're a business coach and you have a lot of claims on your website that you can get people to $100,000 months or years, you might want to have a disclaimer in there that you might not help them get there unless that's a specific guarantee that you're getting. Like they are actually responsible for making sure that they do the work to get the results. Or if you are a health coach, disclaimers that you're not replacing advice from their doctor. Or if you're a financial coach, that they should really be checking with their accountant about tax issues that might arise for them. So just making sure that any disclaimers are specific to your expertise and the service that you're providing. Usually I see this a little too generic, or I can tell when these have just been copied from someone else that's outside their industry because they're not specific to what service they're actually offering. So just making sure that these are really specific, because that's what you have to rely on in the event there's ever an action. You can also limit your liability under contracts. Now, this changes from state to state or province to province, but you can say, in the event of a claim against me, we are limiting the amount that I can be sued for instance, to say the amount paid for the previous year in the contract, or limit to a certain amount. Now, this might not always be interpreted 100% per what your contract says, but at least it gives some parameters in the event of an action. Now, other legal terms that are often glossed over because they're the fine print, but actually become really important in the event you ever have to rely on your contract in a legal situation, is a governing laws clause, and that is making sure that the laws where your business is based govern and rule the contract. And that just gives you a starting point, so that if you have a client in Germany, for instance, and you're based in California, that the action has to be heard in California and isn't interpreted where your client is based. Dispute resolution, that's a great one to have in there as well. Maybe we try to negotiate and then go to mediation or some kind of other binding arbitration, something that's not a full-blown court action. Again, this might differ from your jurisdiction where you're located in, but it's a great starting point. And then making sure that you have a clause in there that says that things can be signed electronically. This is becoming less important as we're moving to this being the norm, but I think it's just a good reminder that everything that is signed electronically is legally binding. So the next contract I want to move on to is, and making sure that you're compliant as we're rolling into Black Friday busy season, is making sure your website is compliant. And essentially your website terms of use or your website conditions, however you call it, is your agreement with the public on how they can and cannot use your site. As somebody who was just emailed yesterday telling me that they found out that my site's been copyrighted, I was really happy that my website terms are pretty dialed in terms of my copyright provisions. So that was a fun thing to find out and rely on yesterday. But basically, your website terms of use tell people how they can and can't use your content. This is copyright law. So if you have freebies or blog posts or something like that, you can say, hey, you are more than welcome to use these resources, implement them to help for the purpose that they've been posted, but you can't just take them and copy them. You can't resell them. You can't share it with with your friends without letting them know that I'm the owner. Especially in the digital download world, this is becoming not only harder to track, but more important as we put these resources out into the world. As we're rolling into Black Friday, it's a really great time to go through your own website terms of use, especially if you are selling anything on your website. So make sure that your sales policies are really dialed. So making sure your refund policies are clear. If you have physical products, that your shipping policies are clear, who's paying for shipping, all these kind of things. We've talked about this a few times now, but disclaimers on your website, really important. Just making sure that if you have blogs or content and you're taking a specific angle on the content, which we all are, are using our own personality and advice, that you're just telling people, like I did at the beginning of this workshop, it's for information and educational purposes only, and you are responsible for how you interpret and deal with this content in your business or in your life. And then, like, literally the most boring contract on earth is your privacy policy, but it is legally required to have one. We are in an era where we need to understand how we are dealing and collecting people's personal information. And if you have a website, you just need a privacy policy. There's no ifs, ands, or buts about it anymore. You need to be telling people how you're collecting their data, why you're collecting their data, what you're doing with it, what you're not doing with it, how they can request for their data to be deleted under certain laws. So it's just really important that your privacy policy actually reflects your business and the software that you're using, and that it's specific to your own site. A dead giveaway, if you've stolen someone else's privacy policy off their website, is that it says that it's governed by the laws of California. If you don't live there. I feel like I see this all the time, and it's kind of funny at this point, but just making sure that your privacy policy actually is specific to where you live, to the people that you're serving, and how you're dealing with their data. And I'm happy to talk more about privacy policies after if you have questions about that. Okay, as we are rolling into Black Friday, email marketing is on the top of everybody's mind. There's also been new rollout from the FTC, which is the Federal Trade Commission in the US, which really is the governing body that deals with influencer marketing, email marketing, anti-spam, all the things. So it is important to make sure that we know a little bit about this. And again, this is more of an issue spotting. Hey, I heard about this. I want to double check. Informational session versus, I don't want you to be an expert in the FTC laws, but just knowing a little bit of information is really helpful. So the three main laws we're going to be talking about today are the CAN-SPAM Act, and that governs email marketing in the US generally, the GDPR, which is the big one in the EU, that kind of shook the core of privacy legislation fairly early on in the online business space, and then CASL, which is the Canadian anti-spam legislation. So when I'm talking about what is deemed legal and compliant, I'm trying to capture everything that is in these three laws, because it's very likely that if you have a website and are marketing in online space, you're going to have people who are based under and governed by these laws in your world. And the thing about privacy and email marketing laws is that the laws where the user is located, not your business, is what governs. So if you're based in Alberta, like where I am, and in Canada, but I have somebody from California coming to my website, it's actually the laws of California that generally govern our interaction. So that's just something to be aware of. Now, the basis of all these laws is protecting people's privacy and making sure that we're minimizing what would get leaked in a data breach, and then also making sure that people are being aware of how they are dealing with people's data, especially in this age of data breaches. And the big thing around email marketing is making sure we have consent from people to actually be on our email list. So I want to dive into a little bit about what that looks like, as well as just some general things to think about to make sure your email marketing is compliant. So number one, legal best practice to be compliant is have such clear opt-ins for consent. And we are all actually very familiar with what this looks like. But the best practice is express active consent to opt in to your email list. So when I go to Dubsato's website, or if you come to my website, I will probably have some kind of pop-up that says, hey, join my mailing list in exchange for a blog or a resource or a coupon. And it says, put my name, my email, and a checkbox that says I agree to subscribe or something along that, being very clear that in exchange for the resource or the freebie, I am agreeing and consenting to be on your email list. That is what we consider express consent. And the active part is actually the physical click of that checkbox. So it is not okay to have that checkbox pre-checked. We need people to consent and actively check that box to qualify as consent. Now, the biggest other piece of this to be compliant, especially in the US, is you are required to have an easy way for people to opt out, which means unsubscribe to your email list. And this should not be complicated for people to get off your email list. It should literally be unsubscribe, you're off. I've tried to unsubscribe to a few email lists recently, just trying to manage my inbox a little bit better. And it's like all these lists and different I'm on this maze to try and get off the email list, and that is not considered compliant. Make it easy. Every single email marketing platform out there that is reputable has an unsubscribe button that's very easy for you to implement. So just make sure it's pretty easy at the bottom, and it's very common at the bottom of every single email for unsubscribe. So just make it really easy. Don't make people jump through hoops to get off. The other thing that's coming a bit more top of mind, especially since these new marketing laws came down from the FTC recently, is making sure that your email's subject line is not deceptive and clickbaity, for lack of a better term. So you can't say you've won $500 and then nowhere in your email have anything related to that. You can't clickbait or dupe people into opening your email. So just making sure your subject lines aren't deceptive. Clearly, there's some gray area around this because we're all trying to come up with like catchy subject lines, but just making sure it's not blatantly deceptive is very important. So again, just keeping in mind how to make your email marketing compliant. Make sure that you really understand how to delete data if somebody comes to you and says, I need you to delete all my data from your email marketing. Again, most reputable email marketing platforms have a really easy way for you to delete the data and then show a record that it's been deleted that you can give to the subscriber. So making sure that you generally understand how this works. And honestly, most email platforms have a whole help section helping you to be compliant with all these laws. So when you're choosing a platform, it's a really good idea to just make sure that they have a very robust help section for this. You also have to actually maintain consent records under some of these laws. So again, this is all done. Most email marketing platforms have these consent records set up from you. You just have to navigate to find it. But if anybody comes knocking saying, hey, how did I get on your email list? You can show, hey, this is the path of how you got there, and I'm happy to unsubscribe you and delete your data. Now, controversially, and this is something I've been talking a lot about in my Instagram stories this week, is you actually need to include a physical postal address in all of your emails and in your privacy policy on your website as to how you can personally be contacted. And for big corporations or people with an office outside of their home, this is not an issue. But for many of us who work from home, this is a huge privacy and security issue. But it's still a legal requirement. So how I've been dealing with this recently is I actually got a virtual mailbox at a co-working space, and it's simply a virtual mailbox membership. So I pay a monthly fee to be able to use their storefront for all my email marketing and website compliance. So you can use a post office box, you can go to use UPS, I think even FedEx. Locally to you, you can get a mailbox. But this is just something to think about because there are actual trolls going out with lawyers who are helping and just scanning websites right now and emails to see who's not complying with not having privacy policies and physical addresses, and starting these really frivolous claims and saying, hey, if you send me $500, I'll drop the claim and not report you. And it's turning into quite the big business. So figure out a way that you feel comfortable to make sure that you have a physical address in your emails and on your website. And my recommendation is using a third party to do this. There's a bit of cost involved, but I think from a privacy and a security point of view, it's the way to go. I know I act as registered office, and for a lot of my clients and my law firm, it's often a service that lawyers and accountants give to their clients. And again, I'm using this co-working space for that. And then lastly, ensuring your sender information, name, address, and reply to email really clear. This is pretty straightforward, but just something to double check. So before we get into like a fun one-sided game of is this consent, I just want to talk about double opt-ins and maintaining a healthy list. I am by no means an email marketing expert, but these are questions that I get asked quite a lot. So I thought I would just highlight them today. So double opt-ins, when you get the freebie, you've signed the form, and then the next opt-in would be like, hey, we saw an email that went out and said, hey, we saw that you wanted this free resource. Do you want to be on our newsletter still? And that's a double opt-in. So it's not legally required, but I think it is trending towards best practice as we're having more discussions about ethical marketing. It also reduces risks of spammers and bots who just got on your list because they were spam, and helps increase your deliverability. But this is really the best way to ensure consent, and also just making sure people want to be there. There is a big conversation I won't get into today about whether it's ethical if people just want one resource to then get on your email list for the foreseeable future because they just wanted this one resource. So the double opt-in helps mitigate that. Maintaining a healthy list, another great way to make sure everybody's on there who wants to be. Scrubbing your list, which means removing inactive subscribers, or as I've done in the contract market, sending an email saying, hey, this is where we're going with our email marketing. Do you still want to be here? I do this from like a business perspective because I'm paying for every subscriber that's on my list. So I want to make sure they want to be there just to keep more money in my pocket. So it's just something to think of, and helps reduce people marking your email as spam who are too lazy to unsubscribe. So as we are generating our email marketing campaigns, I want you to think about how most of your subscribers actually got onto your list and whether you actually truly have consent from them to be there, because it might be a good time to re-opt them in or scrub your list, or think about, okay, this is where I got them. This segment I don't have consent from, so I'm going to just send them a newsletter saying, hey, do you really want to be here? Click yes to opt in for the future. So acceptable forms of consent, they've submitted a form or a sign-up sheet on your website, click the button, and they want to be there with you. That's great. It's probably the most common way of people getting on your list. If they've opted in from another email, so maybe you sent them some kind of one-off email, or someone sent them your email and said, hey, I think you might want to be on this newsletter, and then they opted in from there. Great, that's consent. Under US law, for sure, if they've made a purchase from you in the last 2 years, that technically means you have consent to roll them onto your email list. Again, this comes back to like, did they purchase from you and really want to be on your email list? It might be, hey, we saw you made a purchase. Here's another email follow-up that gives us your consent to put you on our newsletter. But technically and legally, it's compliant if you just roll people on automatically to your email list if they bought from you in the last 2 years. If someone converts on an ad, that's consent. And technically, if you have a signed written contract, like a client service agreement, that is considered consent to be on your email newsletter. Again, this is not something that I practice. I'm really intentional about having people on my list who want to be there. So it might be something that you say, hey, as part of your onboarding, this is how you can sign up to be on my newsletter if you want that kind of information from me. So unacceptable forms of consent. So if you have a bunch of email subscribers on your list who got here this way, you might want to think about really figuring out a way to get reasonable consent or compliant consent from your list. So if you've bought, rented, borrowed, or done list swaps, that's really not an acceptable way to get people onto your email list. Now, that means actually taking all the people on your list and sending them to somebody else so that they can email them from their email address. That is not considered consent. You can definitely have someone guest email on your newsletter. Like I do that with my list. I say, I get asked to send a letter to somebody else's list, but it's coming from the email address and it's very clear that it's a guest email. So if you've purchased email subscribers, I would think about trying to get that active express consent from them or others scrub your list. Personal business contacts from a previous company, or if you run two different businesses and have two different email lists, they're not interchangeable. You have to think of companies as individual people in the eyes of the law. I have a law firm and I have contract market, and the people who are on my contract market email list do not get emails from Wild Coast Law. They are not interchangeable. Or if you left a company and that's providing similar services to your business, you don't get to pull people, your contacts from that company and put them on your list. They have to opt in. Lists from events you spoke at or attended. This seems to be happening more often as we're moving back towards more in-person events. If you host an event and you can't actually sell or give away the list of emails to any of the speakers or to any attendees or sponsors or anything like that, people have to opt in. So just something to keep in mind about for events, and maybe instead have QR codes for your own business that you meet at events, or if you're speaking, people can connect with you and opt into your list specifically. Manually adding from direct email. So if you get a cold call email, you don't get to auto or manually put them on your list. They have to opt in. And I see this a lot, and I actually do it myself, which is like, hey, I'm sending out a newsletter I think you might be interested in tomorrow. Drop your email here and I'll add you to my list. So what I'm actually doing is I'm sending them a personal email after the fact and saying, hey, I saw that you're interested in being on my email list, and this is how you can opt into this. And that's how I do that. So just auto having people put into the Instagram message box, and then you manually upload them into your email marketing platform. It's not consent because there's no record that's going to be created for that. So just doing it in the way I suggested would be a workaround for this. And on that note, we're going to move over to questions if there's any. Trevor, I can let you jump back in.
There we go. Perfect. Thank you so much for all that, Jamie. That was so much good information. And we have actually a ton of questions to go through as well.
Okay.
I told you ahead of time, I was like, I think our users are going to love this because there's so much of this that is detailed, right, that you need to understand as a business owner. And this is much needed, I think, in our community to understand the ins and outs of this. So let's take a good chunk of time here and get through some of these questions. Sounds good? I actually have some questions myself, but let's jump on to some of Sharon's questions first, and we'll kind of work our way back. So Sharon first asked, if you only have a landing page and not an actual website, does that mean that all the same legalities are going to apply to her for email marketing, or does it operate differently if she's just kind of one page, essentially that landing page, and it's not functioning as a more proper website? What's your thoughts there?
Still need a privacy policy, because you are somehow collecting data from users, and that might not even mean email addresses. It could just mean the cookies and the tracking icons that are happening in the back end of your website that I honestly don't understand, but that help me run my business. They are collecting data. So yes, you need a privacy policy.
Exactly.
Minimum. Yeah.
That's pretty much what I figured. And we had another question. It looks like maybe it got removed, or maybe it didn't get pushed over, but someone was asking about that specifically, right, for cookies and that kind of thing. So you're still specifying what you are tracking in that privacy policy as well, right?
Yeah. And when you'll often see on websites that you have that I accept to the terms of use of the website, the privacy policy, and then a second pop-up will come up like, hey, choose your cookie.
Right. Exactly.
action, you still need consent for that too. And most websites make this pretty easy to comply.
That exactly. Cool. So
Yeah.
that's what Karen's other question was in the US, right? If they need to have opt-in or out for cookies, and that's pretty standard, right? Most
Yeah.
people, I think, are accustomed to having that kind of pop up on their page.
Yeah.
Um, but she was also specifically asking if they don't have the option for them to opt out of that, that would be illegal then, correct?
For cookies?
Correct. For cookies or
Yeah.
tracking, if it doesn't pop up effectively, right?
Yeah. I'm not sure if that's in US or GDPR, but it's just best practice to be
That
able to opt out. Yeah. And
totally.
it's really a lot of these laws are making sure people have control over their data. So cookies is one of them.
That makes total sense. Cool. All right. Next question from Sarah. She was just kind of reiterating or doubling down on that idea about using a PO box or that virtual mailbox you're talking about, just so you don't have to use your personal address. I think you effectively answered that, right? Like you don't need to use your personal address if you really don't want to, which I very much understand not wanting to. I had a
Mhm.
question on that front though, which was I'm actually a little bit unfamiliar with the idea of that virtual mailbox service that you use. Do
Yeah.
you actually receive mail there, or are you simply using a service that you pay a fee to them to use their address and that's it? Or how can you give me a little bit more information about how that service operates? Since at least I'm unfamiliar, maybe some of our users are unfamiliar as well.
Yeah, sure. So they're actually collecting my mail for me.
Okay.
So I've changed my address for every contact that I would be getting
Mhm.
mail for, including as a law firm. I act as registered office for a lot of my clients. So all the mail is getting funneled to this co-working space.
Cool.
And then they just let me know it's available for deliverability. So there's actually no breach of confidentiality or anything. I just send the FedEx to pick it up. And to be honest, there's so little physical mail these
Yeah.
days that
Yeah.
it's really just for
That totally makes
and
sense.
to be compliant. Yeah.
Yeah. Totally. Um, looks like we have another question here from Olivia on the same topic. So she was wondering if they can confirm. Oh, she's just asking again about a PO box. Yes. So Olivia, to answer your question directly, a PO box is fine to
Mhm.
have as a physical address for your
Yeah.
mailing address. Cool.
I just want to make one clarification on this because it can be confusing. Is for if you have formed a company, like incorporated your business or have an LLC, there's often requirements that your records office can't be a PO box.
Mm,
It has to be physical.
okay.
But for email marketing and being compliant from a privacy point of view with email and your website, a PO box is totally fine.
Got it. So
Yeah.
for a lot of our users, that might look like this, where if they do work from home, right? If they just have their own small business, they might have their records office address as their home address, but it's not
Yeah.
necessarily publicly facing, right? They're using the PO
Exactly.
that's publicly
Yeah.
facing. Fantastic. Okay, cool. Sweet. Moving on here. Let's see. Mark that one as answered. Okay. Christy was asking, I've had people tell me to change the opt in here button to say something like get your freebie as a way to have them opt in. And would that be legal if she were to do so? Or is that a
You
bit
can
deceptive?
you can for sure say, hey, and get your freebie here.
Mhm.
But then at the bottom it says by clicking this terms of use, I accept so and so's website terms of use privacy policy. That should be a button that sits clicks,
Mhm.
and it should say somewhere along the line of like the term that you're subscribing to the newsletter.
Got it. So you
Yeah.
need to be somewhat explicit in them opting into it. You can't just have it say get your freebie, click a button, and it does not mention
The
the.
terms of use can say that's where it should be hyperlinked
Got it.
and say, hey, as part of you agreeing to download or give us your email, we're subscribing you to our newsletter.
Got it. Perfect.
Yeah.
Thank you. All right. Next question here. So just to double back again, I think you answered this pretty well as additionally, but Sadie was asking if the governing laws are going to be specific to your state or country. And it sounds like obviously yes, but I think my question to tack on to what Sadie was asking is, and you may not know the answer to this, that's totally fine, but how specific are some of these laws? Are they in the US? I would assume they'd be different by state, or is it more like, I know in some cases, California is like, for example, really strict on some things. So a lot of states kind of
Yeah.
follow the lead of the strictest states. And in Canada, is it somewhat similar, but just a little
Yeah.
bit more digging deeper on that regionality for where people are.
Sure. So they're actually kept for the governing laws clause specifically, we keep it pretty general. So it would say for client service agreement, I think it goes something along the lines of this contract's governed by the laws of the province of California, or sorry, the state of California, and the federal laws of the United States of America where applicable. So you have some play between if it's state law or federal law, those are going to govern. And again, these are parameters we hope that if this ever goes in front of a judge that they respect, but sometimes it's the wild, wild west and they just decide something else. So it's just parameters. I always like to remind people that contracts are not 100% bulletproof, but it's way better to have something in place as a reference point than not.
Totally. That
Yeah.
sounds great. Tacking on to that idea, Chris was asking if they provide services in both Mexico and Canada, do they need two separate terms and conditions and privacy policies as well, since those laws might differ?
Because you would have to, you'd have to make sure that your privacy policy and security are compliant with whatever secure like privacy laws Mexico has.
Hmm.
I don't know. I'm not familiar with what they are, but
Sure.
it seems the general consensus is the GDPR, US privacy laws, and Canadian privacy laws are amongst the strictest.
Okay.
So it would be a good idea to hire local counsel in Mexico to make sure that you're compliant. But it's probably, if you are compliant with those three big laws that we were talking about, it's likely you're pretty close.
Okay. Fantastic. Yeah. Cool.
And you don't need two. You just need to make sure that everything's compliant. Yeah. Because you can't really govern where people are coming. It just becomes too complicated.
Definitely. No, that makes sense.
Yeah.
All right. We got that one. Oops. There we go. All right. Sharon asked, do you recommend addendums if the terms change slightly, or do you just create a new contract? And there's a fun Dipsado play in here, but I want to see what your answer would be just off the cuff. What would you do if you had your terms and conditions changed?
So that's a great question. Terms of conditions or
sorry, she just mentioned
client contract. Let's talk about contracts because
Sure.
Just generally at the top of every website terms of use or privacy policy page you'd have on a website, you could say last updated on, give the date, and then that's it. People agree that they agree to the future changes.
Sure.
But for a client contract, say the scope of services is changing. Say they want to add on more because you've done such a great job. That would be what we call an amending agreement. Okay. So it's actually saying, relating to the specific contract, we're actually changing something so that for that specific clause or clauses, we're making the change, but the rest of the terms of conditions remain the same. Because you don't want to open up the whole contract. So you want to make sure addendum usually means something extra, where amending usually is changing something that's already there.
Got it. So the fine detail difference between an amendment or an addendum, right? So if we're amending something, we're editing. If we're addendum, we're going to add stuff. Yeah.
But like from a legal perspective, if you use both an addendum agreement and the bulk of it's pretty clear, you're going to be okay. So I don't want people to be panicking if they've been using an addendum versus an amending agreement. Yeah. If you don't want to open up the contract and have your client say, oh, actually, I'm getting out of this altogether, just use an amending agreement.
Got it. And on the Dipsado end of things, obviously, right? So if you're unfamiliar, a subcontract or a sub-agreement, we kind of use those two terms interchangeably, would be a perfect use case for something like an addendum or an amendment, right? Yeah. You've already got a signed contract from your clients. Each project can only have one contract. So you're going to go ahead and add in a sub-agreement to make those changes or add some things.
Okay. And love the paper trail. Do not make changes. I will say this on blue in the face. Do not make changes by email that are not followed up in an amending agreement, because you don't want a lawyer reading your whole email correspondence. It's really expensive. So just have the paper trail.
Yeah. I can only imagine. Yeah. And on that point too, I've had plenty of times where folks have asked like, hey, something did change, and their gut reaction in Dipsado at least was to remove or effectively delete the old contract and just send a new one. And it's like, well, no, hey, hang on a second. Like you want to keep the record that contract was signed on X dates. And then obviously you can send that sub agreement. You don't have to throw out, like you said earlier, the baby with the bathwater. You don't have to tear it all down, right? You can keep that. Cool. All right. We're almost through all these questions here. We'll keep on trucking. Let's go ahead and there we go. So Clary asked a little bit longer of a question. So she said that she has used your contracts in the past and she loves them. So that's fantastic to hear, obviously, off the bat.
Hi, Clary.
Okay. I obviously, you know Clary.
Yeah.
She was wondering about creating a legal contract for a wedding venue. She's a wedding venue owner in Nova Scotia, Canada. And where can she get started if she can't afford a lawyer for the full contract creation?
I would say I don't have a venue contract yet, just because it's so specific with respect to insurance. But I would say if you can't hire a lawyer right now, I would say like make a list, sit down and like think about the most important things that your people booking the venue are going to need, and also get in touch with your insurance broker and figure out what they need to know um, is covered in your contract. Like if someone's having an event at your wedding, are they in charge of day insurance for that event, or are you? What happens with cancellation, all the things, but you and I can talk offline about this a
Okay.
little bit more. It's pretty specific.
Yeah, that makes sense. I mean,
Yeah.
I think that's some of the situations that a lot of our users are in where they're like, hey, I understand all these pieces and my industry is specific enough where you might need to have a little bit more of a fine-tuned approach.
Yeah, that's a higher risk industry. Events,
Oh, okay.
events, construction, things with kids, food. Those are all the things I think best to work with the lawyer, the risk of claims in these situations.
Totally. That makes sense.
Yeah.
Cool. All right, just a couple more here. So Sadie asked, how much information and detail should you have regarding mediation and arbitration in your contract? I think it's a good question because I think if you put a ton of content in your contract about that, that kind of topic, your clients might be like, well, this is like, why do I need to, what I'm saying? Like, that's a
Who's
little
the
bit.
common denominator here?
Right, exactly. So, but what are
Yeah,
your
I
thoughts?
think just setting out like how you're going to handle the disputes. I think in the online space, a lot of them is like, let's do fair negotiation. And then it also depends on your specific jurisdiction. Like I know in British Columbia, we have a minimum. If it's $5,000 or less, you're actually not allowed to go to small claims. They
Okay.
just do virtual mediation, and it's set. So that's kind of the end of the road unless you want to go arbitration. But just saying, hey, this is our general way we're going to handle disputes, and we agree not to go to a judge. We can do binding mediation or binding arbitration, just giving some parameters.
Totally. Cool.
Yeah.
All right. And this looks like last question for right now. So Cedric asked if his client is in another state and signs the contract electronically, and he obviously lives in his own state, which would be the governing state? Let's say for hypothetically, the two states had a slightly different policy, but is it the client states or the user states, or does it default to federal, or what would that look like?
It would be first where your client or contract says the laws are. So that's that governing laws clause. And if that's silent, then it would be the laws of whoever to start an issue to interpret the contract. So if that person is in Minnesota, for instance, they might just start an action in Minnesota because there's no jurisdiction set.
Got it. Okay, cool. And then Sharon asked one more question about the virtual mailboxes. Does the address need to be in the same province or states, or does it need to, or can it be in a different state, different province from where your business location might be?
I'm not aware that it has to be in the same province or the same state. Mine's in a different province because I just moved. So, yeah. So it's all there, and then I just get it sent to me. Yeah.
Fantastic.
Yeah.
All right. Thank you so much for hanging in there for the marathon questions that I.
That's great. I love questions. It's like I'm also making notes for content, so I love that.
Yeah. No, I mean, definitely a great place to get some feedback about what folks are curious about, interested in, what they need. So I'm glad this was hopefully helpful to you as well. I hope this was super helpful to all of our users here today. Like I said, a lot of stuff to go over. We're going to make the slides available in the replay or in the email that the replay is going to be sent with. So you can review these slides later if you need to. You can also find this on YouTube in about 24 hours. Jamie, let me go ahead and throw in the link that you sent me. So in case folks want to reach out to you, let me grab that.
Yeah, I love answering DMs and just connecting. So if something piqued something that you just want a bit more clarification on, my DMs are always open.
We thank you very much for that. I'm sure some folks will take you up on that. But otherwise, no other questions remaining here. So let's go ahead and call it here. And I just want to thank you one more time, Jamie, for all your time today. It's been fantastic. I'm really happy with how much stuff we got through. So I hope you have a really good rest of your day. And everyone for being here. I appreciate y'all being here. Have a great rest of your day. We'll catch you on our next webinar. Thank you so much.
Thank you so much.
Bye, everyone.